Yep, all good to go.
So good afternoon, everybody. Welcome back. I hope everybody is managing their start of term. What are we, 3 weeks in, 4 weeks in?
3.
Stumpy's 4 weeks in to the one's 3 weeks in. So, you know, we're kind of getting to that point now where some students are settling and others have found their feet and starting to bubble. So I hope you're not all too tired. Welcome if this is one of your first sessions with us. This is the Sensible SENCO network session. I'm delighted tonight to welcome Tom from Birkett Long, who is going to be talking to us in a few minutes' time. If you are a member of the Facebook group, please do have a look on there for our post earlier, because we have been nominated for our 3rd award this year, which is absolutely amazing. So whoever put that nomination in, thank you very much. But we do need your votes for this one, please. So give that one a click and find the send section and find Sensible SENCO and give it a tick, please. Anyway, Tom, we've been talking for a couple of months now, and I love your work, so I'm going to just pass over to you.
Thank you very much. Good afternoon. Good afternoon, everyone. As Abigail said, my name is Thomas Emmett. I'm the Head of Education at Birkett Long Solicitors. Just a little bit about us. The education team at the firm advises educational institutions, but also parents, carers and young people on education law. And so that includes admissions, appeals, exclusions, SEN law, but also in respect of institutions, property law, commercial law, data protection law, health and safety, and much more. Today, I'm going to be providing what can only be described as an introduction to the framework of SEN law. And I say introduction because 1 hour is probably not enough to cover the entirety of the framework and the complexities of it, unfortunately. However, I hope today provides an insight for you into the sources of law. So if I could go to the 3rd slide. So that's the next, there we go. I have to give a bit of a precursor to the substantive part of the webinar, just to say that this presentation is for general purposes only. It doesn't constitute any formal legal advice, and the information is correct as at today's date. But of course, later on, it could be subject to changes in the law. Next. So the agenda for today, I'm going to start by covering the sources of SEN law. I'll then move on to consider some of the key definitions used in SEN law, and that can be found in the Children and Families Act 2014 predominantly, but other areas of the law as well and other pieces of legislation. They are really important to understand for the purposes of comprehending and applying SEN law generally. I'll then discuss some of the key areas of SEN law, including the duties the law places on educational institutions relating to SEN needs assessments, plans, and the changing of them. And then hopefully we'll be answering some questions at the end. I think it's useful to start at the beginning and as to what makes up SEN law and where it can be found. The place to start is always the Children and Families Act 2014. From the 1st of September 2014, a new legal framework for SEN law was introduced with the implementation of that act. The legal framework relates only to the law as it applies in England and contains the legal rights to ensure children and young people with SEN or a disability receive the educational provision required as a result of their needs, having regard to the need to help those children and young people achieve, using the words of section 19 of the Act, the best possible educational and other outcomes. There is more to it than that, in that there are other acts of Parliament or statute that also apply, and I will be talking more about those in a moment. But there are also regulations, and the regulations contain the detail that flesh out the acts of Parliament. You will often find things such as time limits, which by law must be adhered to. An example of a regulation is the Special Educational Needs and Disability Regulations 2014. Other sources of law include statutory guidance, and the word statutory is quite important there because it's guidance that has a legal footing. Arguably, the most important example of statutory guidance in this context is the SEN Code of Practice. Statutory guidance does not have the same status as statute or regulation, but local authorities and various other bodies must have regard to it. And that's the key point. They must have regard to it, which means that they must comply with it unless there is an exceptional reason not to. There is also case law, and SEN law is continuously developed by the bringing of new cases to challenge uncertainties in the law. Judges' interpretations of the law become much as part of the law as Acts of Parliament and case law. Turning back to the Acts of Parliament or the statute, in addition to the Children and Families Act, there are some other important acts which you need to be aware of, including but certainly not limited to the Education Act 1996, which was the key act in relation to SEN law before the Children and Families Act. Part of it remain in effect, including the sections dealing with entitlements to free home to school transport, some basic definitions such as child and compulsory school age, which we will come on to later, and section 9 of that act, which is an important section in the context of a parent's choice of school or other institution named in an EHC plan. In addition, there is the Children Act 1989 and the Chronically Sick and Disabled Persons Act 1970, and they're relevant in terms of social care needs and disabilities. Most of you would have heard of the Equality Act 2010 as well, which is a key piece of legislation in relation to children and young people with disabilities. And there is the Mental Capacity Act, which becomes relevant in the context of where a young person may not have the mental capacity to make a particular decision. We know what SEN law is made up of, where it can be found. The next question is, who does it apply to, and what is the scope of SEN law? And as you can see from the slide, the starting point is children and young people. It's not all children and young people, and we'll come on to that in a minute. But for the purposes of doing this as a step-by-step process, we have to start with what does child and young person mean in the law. So if we turn to the next slide, please. So there is a definition of child in the Education Act 1996. There is also a definition of compulsory school age, which we'll see why that's important in a minute. And in the Children and Families Act, there's a definition of young person. So the word child is defined in section 579 of the Education Act 1996 as a person who is not over compulsory school age. Broadly, this means up to the age of 16, because section 8 of the Education Act 1996 states the compulsory school age starts at 5 and ends at the school leaving date, which is currently defined as the last Friday in June, which falls in the academic year in which a child turns 16. The definition of child also covers those below compulsory school age, so there is no need for a child to be at school to benefit from the protections in the Children and Families Act 2014. A young person is defined in section 83(2) of the Children and Families Act, and it means a person over compulsory school age but under 25. Broadly, therefore, the definition of young person means from 16 and up to 25, and a child becomes a young person when they reach 16. So we know from what we've just outlined that SEN law applies to children and young people from 0 to 25. However, that's not the end of it, because to complicate matters, it does not apply to all children and young people between those ages. To determine which children and young people in particular it applies to, you need to look at the Children and Families Act. In that act, there are references to children and young people having either a disability or a learning difficulty. You would also see references to special educational needs. It is important to understand what disability, learning difficulty and special educational needs are from a legal standpoint to be able to determine if the Children and Families Act applies to a child or young person between the ages of 0 and 25, or young person at the age of 25, beyond 16. So starting with special educational needs, section 20 of the Children and Families Act states that a child or young person has special educational needs if he or she has a learning difficulty or a disability which calls for special educational provision to be made for him or her. This definition has two elements. The child or young person must have either a learning difficulty or a disability, and that learning difficulty or disability must require special educational provision to be made for him or her. To determine if a child or young person has special educational needs as defined by Section 20 of the Children and Families Act, you need to break down the two elements and consider those underlined words on the screen and what the law determines to be a learning difficulty or a disability and what it considers to be special educational provision. In terms of learning difficulty or a disability, Section 20 of the Children and Families Act also states a child of compulsory school age or a young person has a learning difficulty or disability if he or she has a significantly greater difficulty in learning than the majority of others of the same age, or has a disability which prevents him or her from making use of facilities of a kind generally provided for others of the same age in mainstream schools or mainstream post-16 institutions. Section 22A is what many people think of when they consider what is meant by the term learning difficulty, i.e. a significantly greater difficulty in learning than their peers. Section 22B deals with a different situation where the child or young person in question may not have a learning difficulty directly as a result of any learning disability. They may, for example, be quite intellectually bright, but because of their disability, as defined in the Equality Act, which I will go on to later, he or she is unable to access mainstream education or training without some steps needing to be taken to enable that to happen. In other words, they are prevented or hindered from being able to access education in the same way as their typically developing peers. Section 23 is a separate part of Section 20 and it's about children under compulsory school age. It states a child under compulsory school age has a learning difficulty or disability if he or she is likely to be within subsection 2, that is what I've just read out, when they become of compulsory school age. This means that for children under compulsory school age, the test is the same, but it looks forward and asks whether or not the child is likely to fall within the definition when they reach that age. It is important to recognise Section 24 as well. So that's 20 subsection 4, which contains a negative. It sets out specifically a situation which does not constitute a learning difficulty. It states a child or young person does not have a learning difficulty or disability solely because the language or form of language in which he or she is or will be taught is different from a language or form of language which is or has been spoken at home. This means that children who have a greater difficulty in learning than their peers, which arises because their home language or dialect is different to the language in which they are taught, do not have learning difficulties as defined in law. They therefore fall at the first hurdle in the question of whether or not they have special educational needs in the legal sense. Now we turn to what the law considers special educational provision. Remember, in order for a child or young person to have special educational needs in law, both of those two elements I previously referred to must be satisfied. They must have a learning difficulty or a disability, and they must call for special educational provision to be made. Therefore, we need to understand this term special educational provision. This is defined in Section 21(1) of the Children and Families Act 2014, which states that special educational provision for a child aged 2 or more, or a young person, means educational or training provision that is additional to or different from that generally made for others of the same age in mainstream schools in England, maintained nursery schools in England, mainstream post-16 institutions in England, or places in England at which relevant early years education is provided. Special educational provision, the definition of that for a child under 2 means educational provision of any kind. The key words to notice are that special education needs to be in additional to, the special education provision needs to be additional to or different from the provision made generally for others of the same age in a mainstream maintained environment across the whole of England. A child or young person has a disability for the purpose of the Children and Families Act if he or she has a disability as defined in the Equality Act 2010. The Equality Act states a person is disabled if the person has a physical or mental impairment, and that impairment has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. Note this test is different. It's about the ability to carry out normal day-to-day activities. But unless the child or young person also has a need for provision, the parts of SEN law which confer entitlement on children with special educational needs will not apply to them. A child or young person might have special educational needs and a disability, or only one. For example, a child or young person with dyslexia or on the autistic spectrum may have SEN but not be disabled. Although, of course, they may be. It depends on the impact on the condition of their ability to carry out day-to-day activities. A child or young person with complex medical needs may be disabled but may not have special educational needs. A person with cancer, for example, is deemed to be disabled under the Quality Act 2010. Again, there is a possibility of overlap, but don't make the mistake of thinking that all children and young person with SEN are disabled or vice versa. In each case, the different legal tests have to be considered and applied. Next. So we've gone through quite a number of different definitions that can be found in various different parts of the law. So we take into account all the information, and the question to ask is, well, what children and young people have rights under SEN law? Well, using the law and the legal definitions we have gone through, children or young people who do not have either a learning difficulty or a disability will not be covered by SEN law at all, because they don't have a learning difficulty or a disability. Children and young people who have a learning difficulty but who are not disabled and do not have special educational needs, because the learning difficulty they have does not require special educational provision, are not considered in law as having special educational needs, because adaptations can be made by the class teacher without any special help, and therefore that child would not be eligible for any EHCP. Children and young people who have a disability but do not have special educational needs, because the disability they have does not require special educational provision, have some elements of SEN law that apply to them, but they would not be eligible for an EHCP because the gateway to the plan is having special educational needs. Children and young people who have a learning difficulty or a disability who do have special educational needs, because the learning difficulty or disability they have does require special educational provision, and the school or post-16 institution they're attending are not able to arrange the provision, those children and young people are entitled to an EHCP. So I appreciate that's all very complicated, and hence why SENCos aren't expected to be lawyers, and that is our job. However, I hope that does give an indication as to the legal definitions that you need to be considering when you're looking at whether an EHCP is inappropriate for a particular child. So we know more now about the sources of SEN law and that it applies to only certain children and young people. We next have to consider what duties SEN law places on other key stakeholders in the education sector, and a stakeholder that SENCos will know well, and that's educational institutions such as schools. It is important to note that before we consider these duties, that not all of them apply to all types of educational institution. Turning to Section 34 of the Children and Families Act, this applies to children and young people who have SEN but don't have an EHCP. It states children must be educated in mainstream settings. Therefore, mainstream educational institutions must educate those children, subject to rare exceptions. Section 34 does not apply where the cost is not met by the local authority or the Secretary of State. That is the cost of educating the child. There is nothing, therefore, to prevent children and young people being educated privately in a specialist setting at the parent's own cost. There are other exceptions as well, quite a number, which we probably don't have enough time to go through today. In terms of Section 35 of the Children and Families Act, that also contains a very important duty, which applies to maintain nurseries and maintain schools, where such settings are concerned with the making of special educational provision for children, and that is most of them. The duty is to ensure that a child engages in activities of the school together with children who do not have special educational needs. And that's obviously very important in terms of inclusion. and again subject to certain exceptions. One being that section 35 only applies so far as it's reasonably practicable and is compatible with the child receiving special educational provision called for by his or her special educational needs, the provision of efficient education for the children whom he or she will be educated, and the efficient use of resources within the educational institution. One of the most important duties within the Act, and actually one that's mentioned quite a lot to me, is section 66. And it contains a key duty on the governing body of a school or proprietors, and that applies to academies or management committees, to use what is described as best endeavours to secure special educational provision for all children or young people for whom they are responsible. Now, there are a lot of intricacies around this. Again, I don't have all the time to go through it, but what I would say is best endeavours is an extremely high bar to reach, and it basically means you have to take all the steps you possibly can within the exceptions set out in the section to meet the duty. So the duty applies to the mainstream schools, to maintain nursery schools, to mainstream 16 to 19 academies, to alternative provision academies, further education institutions and PRUs, but not special schools. Section 68 contains a duty to inform parents and young people if special educational provision is made for a child or a young person at a maintained school, a maintained nursery school, an academy school, an alternative provision academy, or a PRU. This only applies where no plan, so that EHCP, is maintained for the child or young person. So this provision specifically relates to children and young people without a plan. The law requires a local authority to inform a parent or young person if they are considering making an EHC needs assessment of a child or young person's need under section 36(7). There should therefore never be an instance where a pupil receiving special educational provision and the parent or a young person does not know about it. This applies to all maintained schools and academies, and so does apply to maintain or academy special schools. Turning to section 69, this contains the information duties upon governing bodies of maintained schools and maintained nurseries and proprietors of academy schools. There's no corresponding duties on the further education college. This is a duty to prepare what is called a SEN information report. SEN information is defined in that section as information about the implementation of the governing bodies or proprietors' policy for pupils at the school with special educational needs. It needs to include the arrangements for the admission of disabled persons as pupils at the school, the steps taken to prevent disabled pupils from being treated less favourably than other pupils, the facilities provided to assist access to the school by disabled pupils, and the plan prepared by the governing body or proprietor under Schedule 10 of the Equality Act 2010, which is your accessibility plan. The Special Educational Needs and Disability Regulations 2014 contain further detail about what must be included in a special educational needs information report. In your role as SENCos, I'm sure you're very aware of EHC needs assessments and making applications for such assessments. There is a lot said about, I suppose, the bar that needs to be reached in order for an assessment to take place. I'm going to state the law in plain black and white, and if it's not contained in here, I would say it's probably additional requirements that have been added by your local authority, and that's something we can talk about if you have any questions afterwards. But let's start with the basics. An EHC needs assessment is defined in section 36(2) of the Children and Families Act 2014 as an assessment of the educational, health, care and social care needs of a child or young person. The first step towards an EHC needs assessment is to trigger the requirement for the LA to make a decision about whether or not to carry out the needs assessment. And this can happen through two different legal routes. A request can be made or the LA becomes responsible for the child or young person under section 24. I'm not going to go into the latter today. We'll focus on the first one, which is, to be honest, the most frequent that I hear about, which is essentially giving notice for a request for a needs assessment to be carried out. A needs assessment can be carried out by a local authority, and a request can be made by a child's parent, a young person, or a person acting on behalf of a school or a post-16 institution, such as a SENCO. When a request is made under section 36(1), the authority must then determine whether it may, and the key word is may, be necessary for special educational provision to be made for that child or young person in accordance with an education healthcare plan. In other words, the local authority has to make a decision as to whether or not special educational provision may be necessary to be made in an EHCP. This is an extremely low bar to meet because the obligation is to consider whether it may be necessary for provision to be made in accordance with a plan. The local authority has a duty to consult the child's parent or the young person before making its decision. Whether it does or doesn't is a different story, which gives the parent an opportunity, if they have not done so already, to explain why they believe that child has or may have special educational needs and why special educational provision is or may be required to be made in accordance with a plan. From the date of receiving a request from a parent, a young person, or from the school, the local authority must, within a maximum of 6 weeks, again, timescales vary depending on the local authority you work in, but the legal position is 6 weeks, must make a decision within 6 weeks as to whether or not it is necessary to secure the assessment. Within the 6 weeks, if the LA is considering the needs assessment, it must notify the child's parents or the young person of that. Under Regulation 3 of the Special Educational Needs Regulations that I've referred to previously, this must be done as soon as practicable after the LA receives the request or they become otherwise responsible. It must also notify various other people, including responsible commissioning bodies, social services, persons responsible in a school or an early years education provider or a post-16 institution. There are limited exceptions to this in section 36(7). Having made its notifications and carried out the required consultations, a local authority must make its determinations, and there are only 2 possible answers. It's a yes or no question. After the issue will be whether or not the local authority has applied the right test for the purposes of determining the needs in respect to the needs assessment. The legal test is as follows, just to be absolutely clear. The local authority must secure an EHC needs assessment for a child or young person if, after having regards to any views expressed and evidence submitted under subsection 7, the authority is of the opinion that the child or young person has or may have special educational needs and that it may be necessary for provision to be made for the child or young person in accordance with a plan. That's it. That's the legal test that must be applied. It's an extremely low bar. It's highly likely that local authorities will have its own policies and procedures as to whether or not a needs assessment is to be secured, but to the extent that they are stricter and or impose other additional requirements to what is contained in the law, they are unlawful. Paragraph 9.14 of the SEN Code sets out guidance to local authorities in considering whether a needs assessment is necessary. These should not be preferred to the statutory test I've just outlined. They are just helpful examples. It does not mean they are exhaustive examples. If the LA does decide that it will secure a needs assessment under the Special Educational Needs and Disability Regulations 2014, Regulation 6 states it must seek the following advice and information about the needs of the child or young person, about what provision may be required to meet such needs, and about the outcomes that are intended to be achieved by the child or young person receiving the provision. The reference in the regulation is simply to needs. However, bear in mind that an EHC needs assessment is specifically defined as an assessment of a child's educational, health and social care needs. So it covers all of those particular needs. The list of persons from whom this advice and information is to be sought is set out under SEN Regulation 6.1. It includes the parent or the young person, includes a head teacher of a school or post-16 institution where the young person is attending. It includes health care professionals, educational psychologists. What is also key, and there's a lot of questions around whether private reports should be taken into consideration. The answer is absolutely yes. You can submit private reports for the purposes of the assessment and they must be taken into consideration. There are two possible outcomes from a needs assessment. A plan is issued, and at that point, a parent will receive a draft plan, or the local authority will notify that they've decided not to issue a plan after an assessment. If they decide that they are not going to issue a draft EHCP, there is a right of appeal. In terms of the test that the local authority must apply in law when making the decision as to whether a plan is going to be issued, it is as follows: where in the light of an EHC needs assessment, it is necessary for special educational provision to be made for the child or young person in accordance with a plan, the local authority must secure that an EHC plan is prepared for that person, and once an EHCP is prepared, it must maintain that plan. The key word there is necessary, and there is a lot of law around and legal case law around what necessary means. Again, we're not necessarily going to have the opportunity to delve too far into that today. Otherwise, that will be a whole new presentation and we could be here for another hour or so. What I will say, though, is local authorities may have their own policies. But again, if they're stricter than the legal tests that I've just outlined, they're not lawful. The legal test is whether it's necessary for provision to be made for a child or young person in accordance with the plan. That is it. Okay, so section 37, an EHCP, it basically states what an EHCP is, and it's a plan specifying a child or a young person's special educational needs, the outcome sought for him or her, the special educational provision required by him or her, any healthcare provision reasonably required by the learning difficulties and disabilities which result in him or her having special educational needs. In the case of a child or a young person aged under 18, any social care provision which must be made for him or her by the local authority as a result of Section 2 of the Chronically Sick and Disabled Persons Act 1970, any social care provision reasonably required by the learning difficulties and disabilities which result in the child or young person having special educational needs to the extent that the provision is not already specified in the plan under paragraph E. An EHCP may also specify other health care and social care provision reasonably required by the child or young person. As you know, there are various sections to an EHCP. I actually have noted down here quite a lot of information about each section. I'm looking down at the time and thinking, which parts am I going to cover? And I've decided I'm going to cover probably those that come up most often, which is section B, section F and section I. Section B is where the child's special educational needs should be listed and is a key section of the plan. The section should reflect all the educational difficulties identified in the parents and professionals reports obtained during the assessment. Each report gathered through the statutory assessment process should be analysed. It will be necessary to go through all the advice in the reports, highlighting each difficulty and checking whether section B has them included. Another thing to look at is the description of each need detailed and accurate? If it's not, again, this needs to be raised at draft stage. Are there any conflicts in the reports received during the assessment stage? If so, has this been resolved? Again, this is something that needs to be resolved during the draft stage. Once needs have been identified, it helps to number them as you're going through them so that you can match with the corresponding provision which should be set out in section F. And that section F is arguably the one that comes under the most scrutiny, certainly with lawyers, and that is where special educational provision must be set out. We've talked about what the definition of special educational provision is, and that is anything that's additional to or different from provision that is made for others of the same age. This could cover anything from the provision of worksheets in larger font through to one-to-one adult support in the classroom or assistive technology. The code, the SENCO, goes into more detail in the table at paragraph 9.69 and states ultimately what is reflected in case law, which is provision must be detailed, specific, and should normally be quantified, for example, in terms of type, hours, frequency of support and level of expertise, and provision must be specified for each and every need specified in section B. There is some case law around this, as I referred to. Probably one of the most famous cases, a case from 1999, which is L.V. Clark. And to quote a judge, if you don't want to believe me, in very many cases, it will not be possible to fulfil the requirement to specify the provision considered appropriate to meet the child's needs, including specification of staffing arrangements and curriculum, unless hours per week are set out. In other words, it has to be specific and quantifiable. One key point about different types of therapies, section 21(5) of the Children and Families Act is really important in this context. It states that where healthcare provision or social care provision educates or trains a child or young person, this must be treated as special educational provision. Therefore, rather going in the sections of the plan that are about healthcare provision and social care provision, they need to be in section F instead. Really important, because if it's in section F, you can challenge it via special education to SENDist. And there are binding decisions by SENDis applied to section F, where in respect of the provision relating or the areas in the plan relating to healthcare provision and social care provision, they can only make recommendations, which should be followed by a local authority, but there are examples of where that has not been the case. Section I is about the institution, and there is quite a lot of misunderstanding, I would say, about parental responsibility, parental preference even, and when a particular school or institution must be named. Again, there's a lot of law involved in parental preference, and which applies, but it would be fair to say that in respect of maintained schools and academy schools, there is a parental preference that ultimately they must name those schools in the plan unless certain exceptions apply, and it's for the local authority to establish that those exceptions do apply in the particular circumstances. Something that's often talked about is, well, the school is full. School being full is not one of the exceptions, and therefore actually what you need to be doing, to be honest, is kicking back on that and saying, well, actually the school being full is not a reason. But if you're saying that as a reason why you can't take the child, then unfortunately you might be in some difficulty if the parent takes legal advice. Finally, in respect of the plan, what's really important is if it's not specific, if it's not quantifiable in terms of the provision, if all the needs aren't stated, it's not in the final plan, you're going to have difficulty in terms of enforcement. And enforcement is not done at the SEN tribunal, it's done if you take advice via judicial review, and it's normally via a pre-action protocol letter to the local authority, that they're your first steps to ensuring you get the provision that is required. The difficulty is if it's vague and woolly, the words that are often used, then you're not actually going to be able to enforce the plan because it's not specific enough to actually know what the child's entitled to. Our experience is the first drafts of plans are often vague and woolly and are missing things. And therefore, really, you need to go through a plan with a fine-tooth comb if you are helping parents to essentially through the process of trying to obtain an EHC plan. Once that a plan is in place, the local authority can actually decide to amend a plan at any time. However, that is normally done after an annual review. An EHCP must be reviewed within each period of 12 months, starting on the date on which the plan was first made or of the previous review. So if I say a plan is issued on the 1st of January, it must be reviewed by the 31st of December of the same year. If this EHP is then reviewed on the 1st of September, let's say there was an emergency review that was undertaken that year, then there's a new period of 12 months that begins, so you've got until the 31st of August the next year. An annual review is not simply meant to be a meeting which takes place to discuss the child or the young person. It is a key part of the review to see whether the outcomes are still appropriate, whether the needs stated in the plan are up to date, essentially, and I find often that's not the case, and also whether the provision is still appropriate. In terms of amending an EHCP plan following a review, often the suggested amendments will be put to the local authority, and then the local authority will say, well, you've got 15 days. That's it. There's a 15 days to make representations about the plan that we're looking to amend. Key bit here is that it's not 15 days, it's at least 15 days to make those representations. So it can be longer than the 15 days. So I know that's the end, and that's perfect because I've left myself 15 minutes to deal with the questions that I've heard pinging away throughout the presentation.
You have. We've got a couple in here, but thank you, Tom. That was really interesting. And Gavin and I have been having a bit of a mutter as we've been going through and nodding our heads.
We'll put the slide up for your details right at the end.
Yeah.
One of the first questions, one of the early questions that came through was, you were talking, I think we were talking about section 66 at the time, best endeavours. Are those sections useful to refer to when SENCos are being asked to complete consultations and when they're defining reasonable adjustments? Are they useful for SENCos to kind of go in and refer to those?
It's difficult. So you are, I suppose, let's start at the fundamentals, if you like. So the section 66 duty is that the appropriate authorities, that's governing bodies, proprietors, etc., of mainstream schools, 16 to 19 academies, maintain nursery schools. I'm trying to make sure I remember all of them. Alternative provision academies, in further education sector institutions, and there's one more, PRUs, that if there is a registered pupil or student at the school that has special educational needs, those appropriate authorities, as they're described, must, in exercising their functions in relation to the school, using best endeavour to secure the provision. In terms of reasonable adjustments, if you feel like you're meeting your best endeavours obligation and ultimately you can prove that and you're saying, look, we're doing X, Y, and Z, we feel like that's a reasonable adjustment, and this is as far as we can go in terms of meeting that best endeavour obligation, then by all means say that. I'm presuming by consultation here they're talking about when the local authority are asking them, they've received they've received a notification from the authority that the parent would like the child to attend the school.
Yes, usually yes, when they're trying to identify an appropriate placement.
Yeah, exactly. So, which again should be, and I'm saying the word should be during that sort of draft stage element. So again, if you can point to the 66 section and say, look, we understand the section, we're doing absolutely everything we can. This includes these reasonable adjustments that we feel like we made for children with special educational needs. And so therefore we think, or we do not think, that it's appropriate for the child to attend the setting, then by all means do that.
Perfect, thank you. What are the options when the local authority is refusing an EHCP because professional reports have been privately sought? What can the school do to support the parents in kind of arguing back against this one?
It's one of those where I referred to in my presentation about Regulation 6, I believe, of the SEN regs. And in that regulation, it talks about what can be taken into account for the purposes of an assessment. And the last one, I believe, in the list is any other information, or asking for any other information from anybody where it's reasonable for that information to be sought in respect of needs. And that would be a report.
Yeah.
So a privately commissioned report. So to say for a local authority to say I'm refusing to presumably issue an EHCP, to be specific, because a professional report was sought, and to extend it on further, whether this is right or wrong, I don't know, the information in that report we're just going to disregard because it's a private one. It doesn't. There's nothing in law that allows that.
There we go. So refer them back to that final sentence and say, actually, you do have to take these reports into consideration. Yep. Thank you.
And that's not just the reports.
No.
That's anybody else where it's reasonable. So if you've put in your assessment request that a child has a particular need, and let's say that's been diagnosed, and actually on the list that's set out in the SEN regs, there's not a particular, for example, therapist that is listed in those regs, but it would be reasonable to ask a certain therapist to actually provide input, then the local authority should be doing that. And I've heard should be actually going out and seeking that information. And I've heard a lot about sort of it being quite difficult for local authorities to get information at the moment because they don't have enough educational psychologists, for example. It's entirely irrelevant. The legal position is still the same. The time frames are still the same. So they have to go out and get that information from the private sector, if necessary, to meet their legal obligations. Because they haven't got enough, doesn't get them out of their legal duties, unfortunately.
It's great to have this on record.
Yeah.
Okay, this one's an interesting one. So somebody has put, is it lawful to have an EHCP that is not funded? I reckon we could probably take about 2 hours to answer this, couldn't we?
Yeah, I don't want to go into funding because we'll be here a while. The simple, I suppose the simple answer to this is, if you have a final EHCP and Section F is properly drafted with specific and quantifiable provision to meet each and every need set out in Section B, money's not really the question. You just have the provision has to be provided, and it is for the local authority in terms of educational provision to ensure that provision is provided. The whole concept of funding and funding bans, etc., in the context of an EHCP and the provision to be provided under Section F, it's something that has been spun ultimately to distract from the legal duty. And it is an absolute legal duty to provide that provision.
It's kind of separate from it, because if you've got in-house staff who can provide all of that and are volunteering to do it, then technically, no, we don't have to fund it because it's already there, it's available, they can do it.
Well, nobody's raising the question if it's being provided. Yeah. The question is always raised when it's not being provided.
Exactly.
And ultimately, again, this goes back to a point on one of the slides about an EHCP being enforceable, so being specific and quantifiable enough to be enforceable. If it's not enforceable and the provision is not being required, not being provided, a parent has a really tough job of actually getting the provision. And what's the steps at that stage? Well, first of all, you've got to go and get the plan adjusted. So you've got to call an emergency annual review, then get a right of appeal. We're seeing tribunal hearings that are now May and June of next year. So if the local authority aren't receptive to what you're saying, you're going to be waiting until then unless they concede. Once you've then got it changed, if they're still not providing the provision, you're going to send them a pre-action protocol letter for judicial review, which if it's from a solicitor, they'll probably listen. If it's from a parent or even a SENCO, they might not. And so because of those delays, if you like, and not the fault of the tribunal, we had a pandemic that lasted a number of years, you're going to be waiting a long time.
2 years. Yeah.
And that's not acceptable, really. But that is the situation that we're in.
Thank you. Okay, so this one's an interesting, and it comes up quite frequently, actually. Can a local authority force schools to take students whose needs they clearly can't meet? So what we get very often is that every specialist report is saying that special school provision is appropriate. Parents want special school provision very often. Everybody is on the board that we need special school provision. Even the EHCP is saying it should be special school provision, but there aren't any places in special schools, so they're naming the mainstream school and saying, here you go, have this child. What, can the local authority force that?
So they can, basically. Yeah. So it all depends on types of schools that we're talking about here and parental preference. We could be here a while talking about, okay, in X, Y, and Z circumstances, they should do this, but they don't. What local authorities are doing is naming the school they want to name, even though they probably don't actually have sufficient evidence to show that they meet any of the three exceptions. If we're talking about mainstream, academy, etc., that fall within the Children and Families Act, where the parental preference is very, very strong, and ultimately they'll name and they'll say, okay, take us to tribunal.
Yeah.
And what will happen is the child will then go to the school, may not carry on attending the school. There'll be significant difficulties. It can lead to exclusions, some lawful, some unlawful, which then means the child ends up staying at home. It gets into what can only be described as a mess. And yes, I suppose so the short answer is force. I wouldn't like to use that word, but can they name a school that, despite what they've read, is not appropriate? Well, yes, they can. Should they? No.
Okay. Somebody's given it a great name here. They're a holding bay until space has become available.
Yeah.
Which is it's wrong, but until we have more special school places available, there's not really much of a solution. Draft EHCPs, should it stay in draft form, or should it be finalised regardless of any issues that are still waiting correction?
Okay. Before I answer that question, I go back in terms of the schools where the parental preference is strong. Look at section 38 and 39 of the Children and Families Act.
Okay.
That's where you can find the exceptions, but also the types of schools where parental preference essentially should be allowed. So the choice of school should be accepted, save for the exceptions within, if the local authority can argue an exception within section 39. Key bit being it's the local authority's duty to essentially establish that those exceptions apply. The question was, should you just accept a poor draft, finalise it, and then go to appeal ultimately?
Pretty much.
It's a tough one, to be honest with you, because you are now in a situation, as I said, in terms of tribunal hearings where you're May time next year. And therefore, when you finalise, you're going to put in your appeal as quickly as possible. But they could just leave it like that until the last minute, ultimately, and then say, OK, yeah, we don't concede, we accept. But you've waited 6, 7, 8, maybe more months to get to that point. What I would suggest is at draft stage, you put forward the changes that you want to make, all of them. Then if you're lucky and the local authority accepts some of them, that's great, you've made some progress. But I wouldn't sort of go down the line of just accepting a poor plan, finalising it, and wait for an appeal and a hearing. I would try to get as many changes as possible, and that's just about working on the plan as quickly as possible, getting it submitted and let them consider it. You know, it is unlikely that the statutory the timelines will be met anyway, so you might have a period there might actually be another stage where you've got to force them to finalise the plan because they don't meet that deadline. So you may as well have a go at trying to get some of the changes agreed at draft stage. Okay. That's a really tough question, because certain circumstances it might actually be, look, it might be worth finalising it and just going to appeal. A lot of that might be based on institution that the parent's aiming for, or the type of institution. It's quite a tricky question, but generally, you know, there's a draft stage for a reason.
Absolutely. I think all of these are going to be tricky because they're all very nuanced with the context of the school and the circumstances and the rest of it, most of which we can generally apply. But OK, I'm reading directly from the screen now. Do forgive me. Where do we stand when the quantified amount of time, somebody's got a good EHCP if we've got quantified time, detracts from the access to quality first teaching? For example, one plan they've been consulted on has 8 hours of intervention or one-to-one small group. It's difficult to have students out to form the small group because as a school, it's viewed that all the children should be in class. How do we justify taking the child out of the curriculum, apart from the fact you've got a piece of paper in front of you that says it's the law, you must do it?
Well, yeah, and so it goes back to the absolute legal obligation of the local authority to ensure that provision, that one-to-one in a small group for 8 hours, is provided. And if the local authority turn to the school and say you need to ensure this is happening, it has to happen. And I appreciate the school might have an opinion or a view on that, or on how the children should be educated, and that it sort of butts its head against that. But I'm not sure it's necessarily taking the child out of the curriculum either. I don't. That's a difficult one. I'm sort of trying to.
So if I can give you an example, there are some interventions that might be recommended on an EHCP that are very specific for that child who has got the EHCP. But in order to deliver it, you need a group of students. So we're having to take non-EHCP, possibly potentially not even SEN students, out of their curriculum and their entitlement as much as that child, to support that child with the delivery of an intervention. Where do we stand on that?
OK, so I think you can look at this two ways. One, can what's being delivered in the classroom be adapted to allow for that small group one-to-one? If it can't, you then have to question, well, is this provision actually suitable? I think the provision is suitable. The question is whether the institution is suitable. So if the institution is struggling to provide that one-to-one in a small group, sounds like a specialist setting might be more appropriate in those circumstances because it's likely there are smaller groups. So it might actually be going full circle, having considered everything. It sounds like actually maybe the school is just the wrong place for the child if that sort of intervention is required.
That answers the one for. Sorry, we had a question that came from the Facebook group, in fact, the other day, and it was talking about TAs. They couldn't get the TAs recruited because there's a massive shortage of TAs to be able to suit for one-for-one support for their EHCPs. And where does the school go at that point when they can't get the staff to be able to kind of cover the EHCP and the requirement within that EHCP? Sorry, that came up in the group.
The legal, ultimately, as I said, there is this absolute legal duty for the local authority to be providing those individuals. Now, the reality is, if they don't exist, then we're in a chasm of, well, what do we do?
Exactly.
Because ultimately, the local authority in breach of their duty, but inadvertently, or by no fault of their own, ultimately, because these individuals don't exist. Now, the question is, are they available somewhere else? If they're not, because ultimately that's a market shortage at that point. Okay, yep. And that I have a bit more sympathy for, if I'm honest, But I think there are a lot of other areas where perhaps things could be done better.
Yeah, there's a mass shortage of teaching assistants, and very often as well there's a mass shortage of qualified and experienced teaching assistants. So the EHCP will come through with they must have a qualification in ASD or something else. Well, those staff are few and far between. And to get that qualification, they need to be employed by the school, usually in the first place, and they're not necessarily able to do that because they can't recruit anybody to cover the normal positions. So we've got a bit of a catch-22 situation going on, and as Miss White says there, they can't afford the TAs even with the top-up funding. TA salary is not high enough.
I'm looking through some of the questions you've got. I've got to answer one of them, if I may.
Go on, please do. Pick the one out.
So the notional budget being included in the plans, is this legal? Notional is not ring fence and often does not equate to the 6K. Don't put it in, we're not having it in the plans. We do not want it in the plans, okay? Any sort of concept of funding should not be in the plan. It's just about the provision required to meet the need. If you follow through, essentially, the presentation, if you like, when I started talking about an EHCP, and you follow it through, B, F, and I, need, provision to meet that need, and then the institution is appropriate for the needs and the provision. It all follows through in a really neat line. And if you think what essentially provision is, and we talked about what provision is, it's essentially to meet that need, is anything above and in addition to what children need of that particular age in those particular circumstances. Money's not really one of them to meet the need. It might be needed to actually give the provision that's needed to meet the need, but you don't include it. Do not include it. Just the provision, and then the provision will match up with the need. And in any event, the local authority should be giving enough money for that provision to be provided if you can't provide it already, subject to the market forces we've been talking about.
I think it gets quite frustrating because we do get asked, can we supply costed provision maps to the local authority? I don't actually have a problem producing a costed provision map. I think that's useful because they can see how much it's costing us and all the rest of it, and they can see that we're using our funds, which are public funding at the end of the day. They can see that we're using it appropriately. but it's that notional 6,000 comes up constantly. The thing is, what the local authority can't do is say to you, you must be spending over £6,000 to get an EHCP. That is not lawful. I am not a lawyer or legal advisor, but Tom will nod his head at me and tell me I'm right on that one. That is not one of the criteria. So the fact, you know, you might be spending zero on the child, but they could need an EHCP, technically. Technically, she said.
And see, look, and having a look at your questions, I'm seeing the same thing. So people saying they're full, they've just finalised without speaking to anybody. No, we talked about the notional budget. They say no to all private reports. Already gone through, they can't do that. Massive discrepancy between needs and provision. Again, that's probably down to where the local authority have just named an institution within the plan at the finalisation stage without actually taking into account, well, the evidence that's been produced as to need. What would happen if the LA has not updated an EHCP even when annual reviews have taken place? My question is, what is happening in the review? Because what should be being fed back at review stage is, well, and if you're questioning the content, it's probably because provision is not meeting need.
So to give you some context on that one, you will have some secondary schools who are perhaps doing an annual review for a year 8 child now, and that has been reviewed annually very diligently throughout primary school and into the first year of the secondary, and the actual content of the EHCP is still from the original report that was written in year 3, year 4. It has never been legally changed, despite the fact they've changed the name of the school on there, and the provision at secondary is very different to provision at primary. It's not been put into words. There'll be a Word document where a SENCO has highlighted changes and said these are the changes we'll like to make, or we're recommending that are made, but then the local authorities are not coming back with, yes, this has been approved, or this is what it now looks like. What do schools do when that's happening? Shake their head. Yeah, that's a good answer.
What's going to happen? It unfortunately leads to a situation where SENCos need to be lawyers, and that's not their job ultimately. If a SENCO after a review is saying to the local authority, and this is going to come from the parents as well. The parents are going to have the input, or the carer's going to have the input, or you hope, because it's their child, and have said, look, these changes need to be made because X, Y, Z. If they're refusing or they don't make those changes, local authority should be sending a letter to the parents saying, no, we're not going to make the changes. You have a right of appeal. And at that point, you should be appealing, because ultimately the plan doesn't reflect the child's needs or the provision required.
Is there a time scale on that? So after an annual review, how long should the local authority have to kind of make that amendment and send that letter? Is there a time scale? I think there is.
There is, but it depends what you're saying to them. So if you're asking for a change, they should come back to you within 4 weeks and say, yeah, we're going to do this or we're not going to do this.
Right. So I think we all need to start bombarding our local authority with 4 weeks have now passed, and it appears that you have not made the changes requested. Can we assume that we need to take this to appeal? There you go.
Yeah.
That's not legal advice. Okay. Tom, you have been absolutely fantastic, and I'm very aware of the fact that we have run over very slightly. If you guys have any other questions, and I know we've skirted over a couple, we've got Thomas's information on the screen there. He has very kindly said he will respond in brief to some emails. Okay. just like the rest of us, can't afford to give totally free legal advice to everybody, but he has very kindly said that he will do that for us. So if you have got something that you weren't able to ask tonight, or you need a little bit of clarification on something, please do contact him. Tom, thank you very, very much. Do you want to say something?
I just want to say thank you to Tom as well, and we're going to be doing a bit of a partnership with Birkett Long.
Get it right.
I'll get it right. You didn't get it right the first piece. I'll have to edit that piece out. We're going to do a bit of a partnership with Birkett Long. So you'll see them on our website, and you'll see them around the Facebook group as we do more and more things with them. And you'll see us start advertising stuff. So, you know, what?
Nothing.
She's looking at me now like, what, you're advertising? No, we're advertising. We are. So thank you all for being here. Abigail's just put me off completely to what I was saying. And we hopefully see you at the test show as well when you come to that in October. And Tom's going to be there as well, so he's going to come and join us. So if you want to speak to him live without him charging you for it, you can come and
beg
I didn't say I wasn't charging, Gavin.